Hello everyone. In this video, we'll talk about mortgage under the Transfer of Property Act 1882. So when we talk about mortgage in property law, we are not talking about selling the property. That's the first thing to be clear out. Mortgage basically means that a person needs some money but he does not want to sell his property. So instead of selling it, right, he keeps the property as security and borrows the required money. Think of it like a guarantee. The property is kept as a backup to make sure the loan will be repaid. So the focus of mortgage is security, not the sale. Because of this, ownership of the property does not change. The borrower continues to be the owner of the property. The lender, whoever gives the money, does not become the owner just because he is given money. What actually gets transferred is only a limited interest in the property, and that interest exists only for one purpose, to secure a repayment to be paid off the loan. The moment loan is repaid, the interest automatically ends. There is nothing more left with the lender once the money is returned. Let me give you a common example here. Suppose I borrow 10 lakhs from a bank and mortgage my house. Even after taking the loan, the house is still mine. I can say this is my house. The bank cannot say this is the house is belongs to us. The bank only has a right over the house as a security. So if I repay the loan properly, the bank has no claim at all. But if I don't repay, if I fail to repay, then at that point the bank can enforce its security. The person who borrows the money and creates the mortgage is called the mortgager. The person who lends the money is called the mortgagee. So here in this example, I am the mortgager, the bank is the mortgagee. So this is the entire idea of the mortgage. It's kind of security, interest, and repayment. This is all about the mortgage under the Transfer of Property Act 1882. Now let us see the essential elements of the mortgage. For any mortgage to be legally valid, it should have certain elements and that should be present, right? So without these elements, a mortgage simply cannot exist. In other words, not every transaction involving property and money automatically becomes a mortgage. The law checks for a specific requirements. The first and most important requirement is that there must be a debt or some obligations to be secured. If there is no loan, no money to be repaid, and no liability at all, then there is no question of mortgage. Because mortgage always exists to secure repayment of something. The second requirement is there must be a transfer of interest in immovable property. This is an important thing because only immovable property like land, building can be mortgaged under this property act. Movable items are completely excluded. So for mortgage, right, movable items cannot be added over. The next point is there must be two parties involved in the transaction. One party gives the property as a security is called the mortgager, and the other property receives the security and is called the mortgagee. The most important thing is the intention of the parties, the mortgager or mortgagee, must be create security for the debt. If the intention is not to secure a loan, then even the property is involved. The transaction may not amount to a mortgage at all. For example, a property is given only for use or enjoyment or residence and not as a security for repayment of money, then it's not the essential of the mortgage. Now let's look at how many types of mortgage or how many kinds of mortgages that exist. There are mainly there are mainly five kinds of mortgage. That is The Transfer of Property Acts recognize different kinds of mortgages, kind of five or four, each having different legal consequences. These types are based on position, personal liability, and rights of the parties. The main types are in the types is simple mortgage, usufructuary mortgage, and mortgage by conditional sale. There is also English mortgage and mortgage by deposit of title deeds. Mortgage by deposit of title deed is very common in banking transactions today. Anomalous mortgage covers those mortgages which does not fit into any specific category. For example, housing a loan from a bank is usually in a simple mortgage. A village land mortgage where possession is given often as a usufructuary mortgage. Now let's look at simple mortgage. So this is covered under section 58 of 58B of Transfer of Property Act. In simple mortgage, the mortgagor personally binds himself to repay the loan. This means the borrower is personally responsible for repayment. The mortgagor does not give possession of the property to the mortgagee. Means the owner, whoever is taking loan, will not give the property to the bank or whoever the lender or mortgagee. He continues to remain in possession of the property. The mortgagee has the right to cause the mortgaged property to be sold in case of default. If the loan is not repaid, right, then the mortgage has a right to cause the property. However, the mortgagee does not have the right to possession, so he will not take the possession. But if the loan is not paid or defaulted, then only the mortgagee can come into picture to be take some action on the property. For example, when a person takes a house loan from a bank and continues to live in the house, it's a simple mortgage. Now let's look at usufructuary mortgage. Section 58D. In a usufructuary mortgage, the possession of the property is delivered to the mortgagee. So this is the difference between simple mortgage and usufructuary mortgage. In this mortgage, this kind of mortgage, right, the possession of the property is delivered to the mortgagee. The mortgage is entitled to enjoy the rents and profits of the property. The income earned from the property is adjusted towards interest or principal. Generally, there is no personal liability on the mortgagor to repay the loan. The mortgagee cannot sue for sale of the property in this type of mortgage. The debt is usually satisfied through enjoyment of the property. For example, if a farmer gives his land to a lender to cultivate until the loan is recovered, it's a usufructuary mortgage. The next mortgage type is mortgage by conditional sale. This covers under section 58 of C. In mortgage by conditional of sale, the property is apparently sold to the mortgagee. However, the sale is subject to certain conditions. If the mortgagor fails to repay the loan, the sale becomes absolute. Even though the property is apparently sold to the mortgage, right? If the mortgagor is failed to repay the loan, the sale becomes absolute. If the mortgagor repays the loan, the sale becomes void. The condition must be included in the same document. So the condition is included in the same document. If the condition is in a separate document, it's not treated as a mortgage. For example, if a property is sold with a condition that will be returned on payment, it is called conditional mortgage. The next one is English mortgage. This covers under section 58 of E. In this mortgage, the mortgagor binds himself to repay the loan on a specific date. The property is transferred absolutely to the mortgagee. and the property is retransferred on repayment of the uh, money that he took. The mortgage has right to sell the property in case of the default. This is the type of mortgage is commonly used in commercial transactions. For example, large business loans often involve English mortgages. Now let's look at rights of mortgager and rights of mortgagee. To become essential and valid mortgage, right? Both mortgager and mortgagee has certain rights. They should act according to that. The important right of the mortgager is the right of redemption. This means the borrower has the right to get back his property after the repayment. The right exists until foreclosure is complete. It cannot be unfairly taken away. The mortgagor also has a right to inspect documents and claim improvements. These rights protect the borrower against exploitation. For example, even after long delay, the borrower can redeem before foreclosure. And similarly, the mortgagee also has certain rights. The mortgagee has right to foreclose or sell the property in certain cases. This right arises when the mortgagor defaults in repayment. The mortgagee may also sue for the mortgage money. In some cases, he may also get possession of the property. The law balances the rights of both parties. Neither mortgagor nor mortgagee is given absolute powers. For example, the mortgagee cannot take ownership without following legal procedure. To conclude, mortgage is one of the most important modes of transfer under the Property Act 1882. It plays a vital role in banking and financial transactions. Mortgage does not transfer ownership but creates a security interest. Different kinds of mortgages serve different purposes. A clear understanding of mortgage helps avoid disputes and ensure the proper legal actions can be taken on it. If you found this video helpful, like, share, and subscribe. Thank you for watching.